Well, as I sit here today, the state has not yet responded to James Owen's motion for a new trial that he filed on behalf of Sarah Boone. And we went through a number of the arguments, the first three arguments that he makes in those papers in his motion. And we went through some of the case law, we analyzed it, we explored it, and we saw whether the case law actually helps him or hurts him, and whether there's any sort of merit in any of the arguments that he made this far. But today, we're going to jump into the fourth argument. So we already talked about the first three. If you haven't seen those videos, definitely go check those out. And today we're going to jump into the fourth argument that he makes. We're going to be going through some of the case law, which are some of them are interesting cases, and we'll explore it. And again, we'll see whether there's any sort of merit in what he's arguing on behalf of Sarah Boone, that there are certain rulings that were just simply unfair, and therefore she gets a new trial. So we're going to be jumping into that in just 1 minute. Before we do, I'd like to give a shout out to the sponsor of this video, the Suit Depot. The link is in the description. It is a store that sells high quality suits and apparel for very reasonable prices. And for you, a listener of Brother Counsel, you get an extra 10% off of anything that you purchase. Hit that link in the description, and in the coupon box, just type Brother Counsel, all lowercase, no spaces, and you will get an extra 10% off of your order. Go there today. Definitely check them out. A great store. So let's see the actual motion, the fourth argument. It's a short argument, but I think that it's very interesting, and there's a few different arguments that he makes in there, and we have to be careful, as you know, because if you want to look at this critically, you have to really, each line that he's talking about some sort of argument, you got to figure out which type of argument is he making here, and then at the end of the day, think about, is he bringing some authority to support that part of the argument, or is he bringing authority to support something else? Is there a different part of the argument? So let's see what he does, and we'll break it down slowly. So it's a very short few paragraphs here, so we'll be able to read it all, and just be on the lookout for what exactly is the argument. So argument number 4, the court erred in allowing the opinion of the state's expert not previously disclosed. So if you just look at the title for this argument, what does it seem to be the argument that this section is going to be devoted to? It's going to be the fact that these were opinions of the expert that was not previously disclosed, which means it was a discovery violation, right? We know that before trial, you've got to turn everything over to the other side. Anything that you intend on presenting in front of the jury, all experts, all opinions, all exhibits, everything has to be turned over to the other side. Otherwise, it's trial by surprise, trial by ambush. We've all heard those terms used before, and lawyers love to argue that they're being ambushed. This is a surprise. They never heard about this. And sometimes it actually gets you very far. So here, it would appear that the argument here is that the state's expert wanted to give an opinion during trial, which the state did not previously disclose. So it's a discovery violation. That's what it seems to be. Now, if you all remember, if you were watching the trial, you'll remember that there was a time when this expert took the stand, and the jury was sent out a bunch of times, and then there was a proffer, and there was a Richardson hearing held, and we'll go through a little bit more of that as we go on with the argument. But the court eventually allowed the state's expert to give an opinion, which allegedly was not technically given 100% before in the expert's deposition. So now seems like James Owens is arguing that the court erred in allowing that in, and therefore, obviously, an expert's opinion on this matter is going to be so prejudiced against his client, and it's going to prejudice the jury, and you should have never allowed this in, and therefore she deserves a new trial. So let's go through this, and we'll see actually if this section is really devoted solely to that argument, or if he's going to throw some other arguments in there, whether intentionally or not intentionally. So here we go. The trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Dr. Tonya Warner, MD, after the state failed to disclose before trial that the witness had formed a new opinion relating to whether the defendant perceived an imminent threat at the time of the offense. And remember, this is what it ultimately comes down to. Ultimately comes down to is, did Sarah Boone perceive an imminent threat at the time of the offense? Meaning, when George was in that suitcase and he put his 2 fingers out, did she feel an imminent threat to her life, which would then justify her to use deadly force, right? So she was coming to this opinion about whether, in her opinion, Dr. Tonya Warner's opinion, whether Sarah Boone perceived this imminent threat at the time that she killed George. So there was a failure to disclose some of her opinions. So this issue was discussed extensively in the expert witness's deposition taken on October 4th, 2024. The state committed prosecutorial misconduct by failing to disclose this new opinion as agreed in the deposition mentioned above. So let's stop right there. Okay. There's really two separate arguments that could be made here that he's making here. He's actually convoluting them. One is a discovery violation. Okay, you can argue that this was a discovery violation. You didn't let us know about this. This is trial by surprise, trial by ambush, as we just talked about. And therefore, it's not fair that this expert was allowed to give a certain opinion during trial that we didn't know about, couldn't prepare for, and couldn't really effectively cross-examine her on, right? That is one type of argument. There is a second argument, which is really distinct from this first argument. The second is that there is prosecutorial misconduct. Okay, it's a whole different area of law. It has different case law, different interpretations given to prosecutorial misconduct as opposed to discovery violations. It's two separate arguments. And here we see, again, I think, a convolution of both these arguments into one paragraph. And another thing that we see is that in Florida, there's something called a Richardson hearing. Richardson is based, when we say Richardson hearing, it's based on a case called Richardson versus State. And there's something called Richardson hearing, which you have to conduct, the judge has to conduct a Richardson hearing when there's been a discovery violation. And this is exactly what the judge did in this case. He conducted right away, if you were watching the trial, that's what was going on. He conducted a Richardson hearing because there's a Richardson violation. It all goes under the same case called Richardson. Now, if you are going to make an argument that this was a Richardson violation, and therefore there are certain remedies which are the judge is allowed to use, he's allowed to impose based on his discretion, which remedy he feels is appropriate. So don't you think it would be a good idea to bring down this case, Richardson, to cite this case, Richardson, and say that this was a Richardson violation? We had a Richardson hearing, but nevertheless, the judge, you did not impose the proper and appropriate remedy. You should have dismissed the case and then argue based on Richardson that there are certain things that will rise to the level of a dismissal, which is appropriate, and argue that in this case, it did rise to that level, but you don't see any of this done. Okay, so again, the title is not previously disclosed, which sounds like this is a discovery violation argument. And yet you don't even see the word Richardson here. You don't see any sort of analysis about when a discovery violation rises to a level that a certain remedy should be imposed or a certain punishment should be imposed. You don't see any discussion about that at all. And then all you hear about is the jump to the state committed prosecutorial misconduct, which is a completely separate argument. The prosecutorial misconduct is a separate argument, different standard. Everything runs differently. And again, there's no authority devoted to anything about prosecutorial misconduct. Okay, so again, you got to be careful when you're reading this to make sure you understand what the argument is and whether he's backing up with any sort of citations to case law or statutes or rules. All right, but let's move on. In addition, the state's expert opinion on whether the defendant perceived an imminent threat necessary for the justifiable use of force and battered spouse syndrome testified to before the jury was improper. So, in addition to this, what he didn't call a Richardson violation, but what he probably meant to call a Richardson violation, this discovery violation. So in addition to that, the expert's opinion was improper. Why? The state's expert, Dr. Tonya Warner, MD, admitted she had not listened to the defendant's testimony before the jury before forming her opinion on this ultimate issue of fact. Okay, so she agreed, Dr. Tonya Warner, she admitted that she did not listen to Sarah Boone's testimony before the jury. Now, an expert is allowed to watch other testimony. An expert is definitely allowed to do that and then use whatever they learned from the testimony when they're testifying. Okay, so now they're arguing, James Owens, that the expert did not do that. Okay, but what's obviously missing here? What's obviously missing is who says that matters. Just because you could do something, you have to show me by the fact that she did not do that means that her testimony is unreliable. And there's no sort of argument, no sort of citation to any authority which suggests that. So this is just saying, oh, she didn't do this. Yeah, you know what else she didn't do? She didn't, park in a certain parking spot. What does that have to do with anything? So just because she didn't do something doesn't mean that fact that she didn't do it means that it matters. So that's what you always have to do in these briefs. Don't just say that the person failed to do something. Who says that failure is material? Who says that failure means anything? So you got to bring some authority for that, which is very clearly absent from this brief. Continuing. In addition, Dr. Warner failed to listen to the testimony of Dr. Michael Brannon and Dr. Julie Harper before expressing her opinion. So she failed to do this. You're right. Again, she was able to do this, but you have to show, if you're arguing, that the only time that a doctor or an expert can give expert testimony is if they hear the other experts' live testimony. If that's the only time they can do it, show me where it says that. Show me where it says that Dr. Warner can only testify using her expertise if she also saw or heard Dr. Michael Brannon and Dr. Julie Harper's live testimony. So again, no citation to authority. So you already know, especially if you're a follower of this channel, you know that these arguments are going nowhere. You can't just argue to the judge and then expect the judge to feel bad for you. You got to show the judge where in the case law or the statutes or the rules where this is all backed up, where your arguments are backed up. Okay, so let's continue. Furthermore, the state's expert testimony on this issue of whether the defendant perceived an imminent threat at the time of the event violates the province of the jury. Okay, so this is the next argument that we're making. So even though the title, again, you got to be careful because this title is misleading. So the title seems to be that this is a discovery violation. Here, now there's a new argument. The argument here is that the expert testimony is not allowed to give an opinion on an ultimate issue. The ultimate issue in front of the jury, they're arguing, James Owens is arguing, that the state is not allowed to give an opinion about the ultimate issue, which is what they call violating the province of the jury. So let's just let him finish the argument, and then we'll talk about it more. Witnesses are prevented from expressing their conclusions when the opinion only tells the jury how to decide the case and does not help the jury determine what occurred. Okay, so now we do have a citation to a case here where it says that witnesses are not allowed to express their conclusion or an opinion when the opinion is just telling the jury what they should do. So, for example, an expert is not allowed to get up there and say, in my opinion, the defendant is guilty. You can't do that. Or in my opinion, the jury should find this defendant not guilty. You can't do that. That's giving an opinion about the ultimate issue, which is for the jury. That's not for the expert witnesses. The expert witnesses can help them reach to that conclusion, but to actually give the conclusion themselves, this is what James Owens is arguing that this case stands for, that witnesses cannot do that. So we'll take a look at that case in 1 second, but first let's finish up the rest of this. When a witness is asked to express an opinion that applies a legal standard to a set of facts, the opinion testimony is generally inadmissible. So again, here we go, applying a legal standard to a set of facts. So with this set of facts, would you say that the defendant acted in self-defense? That is a question that is not allowed. That's what they're saying that this case stands for. Section 90.703 does not permit a witness to testify to illegal conclusions or express an opinion about questions of substantive law. And then Dubin versus State. The testimony may interfere with the function of the trial judge to determine the applicable law and to instruct the jury thereon, and another case. So anytime, right, he's citing some cases here, so that's good. So you're citing some cases, but all the cases are talking about reaching conclusions or saying opinions that are in the ultimate issue for the jury to decide. That's essentially what it comes down to. So really, this should have been a different title. If you're asking me, the strongest arguments are ones with citations to authority. So this shouldn't have been the court erred in allowing this not previously disclosed. It should be the court erred in allowing testimony on ultimate issues when the case law does not allow that. That's what should be the argument. The court erred in allowing opinion of the state's expert that gives an opinion about the ultimate issue. Okay, that's what this title should have been. But again, we have this title and 4 different types of arguments here, and just a little not as clean as I like to see briefs. But anyway, let's go on to these cases. So for the first case is Moutry versus Bethune-Cookman University, BCU. So let's take a look at what that case has to say. It's a little bit of an interesting case, so bear with me. We'll go through it together, and we'll see what that case actually stands for. This is Moutry. Here we go. Moutry began teaching at BCU in 1977, and except for a brief period from 1979 through 1982, was continuously employed there until 2009. So a very long stint as a professor. When his employment was terminated and this litigation ensued. So this litigation ensued from the fact that he was terminated from his employment. Well, let's see why he was terminated. In 1995, Moutry was awarded tenure, and in 2005, he was appointed Dean of the School of Social Sciences. As a tenured professor, Moutry and BCU entered into annual contracts each year for his employment. Pertinent to this appeal, Moutry's employment contract provides that BCU has the power and authority to terminate this contract at any time for malfeasance, inefficiency, neglect of duty, or contumacious conduct. BCU also had a faculty handbook, which provided that a tenured faculty member may be terminated for cause and listed numerous grounds that constituted cause, including moral turpitude and violation of BCU's policies regarding sexual harassment. The handbook explained the process that occurs following a complaint of sexual harassment, including the requirement that BCU promptly establish a committee to investigate the complaint. So what do they have to do right away? They have to establish a committee to investigate the complaint. Okay, let's see what else it requires. The faculty handbook also recognized that BCU would uphold the rights prescribed by the American Association of University Professors when not in conflict with the policies of BCU. The AAUP manual contained provisions pertaining to charges of sexual harassment that included the right to confront an accuser. So if you're a professor under this AAUP and a student brings a charge of sexual harassment against you, you have the right to confront that student, that accuser. And you have an opportunity to cross-examine the accuser and witnesses, and the right to have specific charges to respond to and formulate a defense. Well, let's see what happens. In May 2009, Reed hired Bo Brewer to conduct interviews relating to staffing for the Academic Affairs Department at BCU. During the course of conducting interviews with BCU faculty members, Brewer was advised of alleged widespread sexual harassment of students by Moutry. So Moutry here is the defendant, he is the appellant, and this Bo Brewer is all of a sudden hearing about this widespread sexual harassment of students by Moutry and other professors in the Department of Social Sciences. Brewer advised Reed of this possible problem, and Reed, rather than appoint a committee, remember what the policies is, you're supposed to commit a committee, supposed to appoint a committee. Well, here, Brewer advised Reed of this, Reed, rather than appoint a committee to investigate as required by the BCU handbook, directed Brewer to investigate these allegations of sexual harassment. So he told Brewer, you investigate it on your own. Don't appoint a committee. Well, let's see what happens now. In conducting his investigation, Brewer promised anonymity to those individuals with whom he spoke. Brewer would thereafter periodically meet with Reed, and when discussing his investigation, intentionally withheld from Reed the names of the individuals making the allegations of sexual harassment. Moreover, Brewer destroyed his notes that identified the individuals he interviewed in order to ensure the previously promised confidentiality. So he promised these victims confidentiality. They never said their names, and he's just doing this investigation on his own. On May 15th, 2009, Moutry received written notice from Reed that he had been suspended from his employment without pay based upon allegations of improper conduct with female students. In this notice, Moutry was advised of the ongoing investigation and was ordered to meet with Brewer to discuss the investigation. Moutry met with Brewer, denied the allegations of sexual harassment, and inquired of Brewer the names of the individuals making the accusations against him. Remember, under the AAUP, he is allowed to get the names and confront them. Brewer did not disclose to Moutry the names of these students. At the conclusion of his investigation, Brewer prepared a written report summarizing his findings and presented the report to Reed. None of the individuals making the allegations of sexual harassment were named in the report, so no names. Brewer's report also summarizes interviews with members of the BCU faculty. The report does not indicate that any of the interviewed faculty members actually witnessed the alleged sexual harassment by Moutry. So nobody witnesses. These are just anonymous victims that are reporting this sexual harassment by Moutry. On May 29, 2009, after Reed received Brewer's report, BCU terminated Moutry's employment and tenure for cause. So he was terminated for cause. The termination letter specifically provided that Moutry was terminated for moral turpitude, violation of the university's policies regarding sexual harassment, violation of ethical code, conduct in violation of commonly accepted standards of morality and failure to cooperate within the bounds of accepted standards. Moutry administratively appealed this termination with BCU. During the appeal process, Moutry claimed that he had never been provided with Brewer's report and had no information as to who was accusing him of sexual harassment. After all, they were all anonymous. The appeal committee upheld Moutry's termination, and Moutry filed the instant suit. So that's how we get here, that Moutry was just fired without for cause, lost his tenure, lost everything, and based on no witnesses, just some victims who are anonymous, and claimed that Moutry sexually harassed them. So on appeal, Moutry argues 4 grounds for reversal, and one that we're concerned about is the third one. Third, Moutry contends the court permitted BCU's outside counsel to provide opinion testimony that improperly told the jury how to decide the case. So this is what really we have to concentrate on, is this third claim here, that Moutry is appealing based on that BCU hired outside counsel, an attorney, this person was allowed to testify. This attorney was allowed to testify and provide opinion testimony about how the jury should decide this case. So that was one of the arguments. Let's go down to where the court talks about this opinion testimony. So here we go. Opinion testimony from BCU's outside counsel. This is, again, the case that James Owens is going to try to show that opinion testimony on an ultimate issue is not allowed. So here we go. Let's see. Next, Moutry argues that the trial court erred in allowing Kelly Parsons Kwiatek to provide opinion testimony as to matters that were for the jury to decide. Kwiatek is an attorney specializing in labor and employment law, who was employed by the law firm that served as outside counsel for BCU. Kwiatek was involved in the investigation of Moutry to the extent that Kwiatek was contacted by Brewer and Reed at various times and advised Reed on the situation as it developed. So while they were doing this entire investigation, they were consulting with their attorney, which is probably what they should do. So Kwiatek now is going to testify at the trial. At trial, BCU called Kwiatek to testify. Specifically, Kwiatek testified that in her opinion, BCU had cause to terminate Moutry's employment and that BCU had provided Moutry with due process. Kwiatek also opined that BCU, again, even though Moutry was not able to confront his accusers, still, this is the opinion of the attorney here on behalf of BCU, that this was for cause, even though there's no witnesses, and this was due process, even though he was not able to confront the accusers. Kwiatek also opined that BCU did not have an obligation to form a committee to investigate allegations of sexual harassment, and that in her view, there was no legal requirement that Moutry was entitled to confront his accusers. So even though the policies in BCU are that they're supposed to form a committee, Kwiatek held that don't worry about that. That's not important. And there's also no legal requirement that he's able to confront his accusers. So let's see what the court held about that. We applied the abuse of discretion standard of review to a trial court's decision on the admissibility of an expert opinion. So again, the standard here is abuse of discretion, an extremely high standard. From a lot of the arguments that we've seen so far in James Owens's brief, in this motion for a new trial, the standard is abuse of discretion, which is extremely, extremely high. Section 90.703 Florida statutes provides testimony in the form of an opinion or inference otherwise admissible is not objectionable because it includes an ultimate issue to be decided by the trier of fact. So this statute is very, very helpful if you want testimony, which is an opinion, and is going to give an opinion about an ultimate issue. Straight out, it says that this testimony is admissible. However, this rule does not render admissible all opinions on the ultimate issues. Witnesses will be prevented from expressing their conclusions when the opinion only tells the jury how to decide the case and does not help the jury to determine what occurred. Okay, so if you're helping the jury to determine what happened, that's okay. If you're trying to tell the jury how they should decide the case, that's not okay. So even though the statute seems to be very, very broad, now the case law is already chipping away a little bit of that and saying, look, okay, you can't just tell the jury what they should find. That you're not allowed to do. You are allowed to help them to determine what happened, which will then lead them down the path, which will get to their verdict. Mutri's breach of contract action was premised on two bases. First, Mutri argued that there was no cause to terminate his contract because he did not sexually harass anyone. And second, that BCU did not follow the proper and required pre-termination and post-termination procedures in firing him. So the second one is the more important one. The first one he's arguing is that he denied ever doing it. But the second one is that the BCU did not follow the proper and required procedures for terminating him. Kwiatek was essentially permitted to tell the jury that, in her opinion, they should answer these questions adversely to Mutri and find that BCU did not breach the contract. That's essentially what all her testimony was. We conclude that the trial court erred in permitting this type of opinion testimony. And in light of Kwiatek's expertise in this area of law and her direct involvement in the process leading up to Mutri's termination, we reject BCU's claim that the admission of this evidence was harmless error. So here, the court is saying that this testimony should not have been allowed. You cannot allow the attorney to just get up there and say, I think it's fine. It's due process. It definitely was due process. And they did everything they're supposed to be doing. And therefore, the jury should find that that he was terminated for cause and he loses everything. That's essentially all she was testifying about, whether, in her opinion, the BCU followed their procedures. So there, the court is saying, no, that's too much. You're really just telling the jury what they should find. So therefore, James Owens is asking, well, now we have the doctor, the state's doctor expert testimony saying that Sarah Boone did not, or should, in her opinion, she did not feel an imminent threat of danger. And therefore, she could have not been acting in self-defense. Well, is that similar or not? Is that the same as the attorney saying that you should find BCU as doing everything right? So I can definitely hear a little bit better the argument as opposed to the other arguments that we made in the first three arguments. I can definitely hear how there can be some similarities. And definitely when it comes to expert testimony, it is a very fine line exactly what is considered giving an opinion on an ultimate issue as opposed to giving an opinion about the science, and you're using your expertise to determine what the situation was. But ultimately, if you are telling the jury what was going on at the time, what the person could have been feeling at the time, that is generally going to be held as admissible. So here is this expert testifying that Sarah Boone did not act in self-defense? Is that what her testimony is? Or is she saying that based on my examination and based on all my review of the records, to me, does not appear that she was feeling an imminent threat of danger. So there's definitely a difference between that and giving it an opinion about an ultimate issue. Here again, if you're telling the jury what the person's feeling, or to help the jury understand what is going on, that's okay. To tell the jury how they should find, that's a problem. So with that lawyer, the lawyer wasn't saying what was going on. They know what was going on. They know exactly what procedures were followed. The only question left for the expert is, do you feel, based on the facts of what happened, do you feel that the BCU did everything they're supposed to do? That's essentially what the question was to the lawyer. The question to the state's expert was, what was Sarah Boone feeling at the time? That's something that the jury cannot get unless an expert testifies as to what she was feeling. So then it's different than telling the jury, she was definitely not acting in self-defense. That's not what her testimony was. Her testimony is, what, with your expertise in psychology and mental health, what was she feeling at the time? That is definitely different than this case. But again, I think it's a better shot than some of his other cases that he tried. But still, if you really wanted to bring out that point, I think he could have done a little bit more of analysis and tried to show similarities between this BCU case, this lawyer, and the doctor, I think it was Dr. Turner, for the state. Okay, but let's move on to some of the other cases. And we'll get also a little bit better understanding of this whole issue of when an expert is allowed to give an opinion and whether it invades the province of the jury. So the next case that they cite is Hunt. Hunt versus State. Here we go. Appellant was convicted of aggravated battery with a hate crime. At trial, the victim and his friend both testified to appellant stabbing the victim. Appellant's wife, okay, I'm going to call it defendant, okay? It's the same thing as defendant as appellant. Defendant's wife and son testified that the victim hit defendant before the stabbing. Defendant's defense was that his actions were self-defense. So he got the defense here is he acted in self-defense. Okay, so there's an aggravated battery, a hate crime, and his argument is that he was acting in self-defense. The state introduced the testimony of a detective who interviewed the victim at length. During the detective testimony, the state directly asked whether, based on his training and experience, there was self-defense used in this case by the defendant. The detective responded, no. The trial court erred in admitting this opinion testimony. So here again, you've got a detective who's testifying that there was no self-defense here. And here's exactly how the questions went out. During the testimony of Detective Heredis, the state asked him the following question. Detective Heredis, during your investigation, did you find that the defendant used the word N towards the victim? Answer, yes. During your investigation, was there any evidence that the victim was hitting the defendant? No. Based on your training and experience, was there self-defense used in this case by the defendant? Answer, no. Based on your training and experience, did the defendant stand his ground in any way? Answer, no. Based on your training and experience, was the defendant defending anyone else? Answer, no. Then there was an objection obviously made. So again, we review the conviction and the trial court's decision to admit the detective's testimony as evidence under the abuse of discretion standard. So again, they're using abuse of discretion. That's the standard that you have to overcome if you're the appellant. So if you're Sarah Boone, this is what you're going to have to overcome if the judge does not agree with you. Appellant argues that the detective heard his testimony about the validity of his claim of self-defense invaded the exclusive province of the jury. That is exactly what the argument was. So first they talk about whether the objection was timely or not. And here we go. When the detective was asked whether, based on your training and experience, was there self-defense used in this case by the defendant, and he said no, the detective entered an impermissible area of inquiry. The law is clear. A police officer's testimony or comment suggesting a defendant's guilt invades the province of the jury to decide guilt or innocence. So, when it comes to police officers, there is explicit case law on this, almost in every jurisdiction. Police officers cannot give opinion testimony about whether someone is guilty or innocent. So this is like black and white. This is clear. Thus, it is clear that error is occasioned where a witness, including a late witness, is permitted to offer her opinion about the guilt of the defendant. It is especially harmful when a police officer offers an opinion of the guilt, or in this case, the sole defense of appellant. Police officers, by virtue of their positions, rightfully bring with their testimony an air of authority and legitimacy. A jury is inclined to give great weight to their opinions. Okay, so that's what this court also held, Hunt versus State. But again, in this case, it's even more clear the distinction between what happened in Sarah Boone's case and in that Hunt versus State, because Hunt versus State is a police officer. Anytime you're talking about the police officer and the police officer is literally saying that the defendant did not act in self-defense, that is an absolute no-no. That's in like every jurisdiction. You're not, the defense, the police officer is not allowed, and they're much more careful with police officers in general because they're the ones investigating crimes, and the jury may give a lot of weight to their testimony. And already, just by them walking in their police gear, already the jury's going to, some jurors definitely may automatically think that they're more credible. So that is always going to be a no-no. Well, the next case that they cite is Dubin versus State. So here's what happened on Dubin versus State. During appellant's cross-examination of the gardens officer, so this is actually a very interesting case, and it's extensive. It's a long factual background, and therefore we can't get into all the facts. It's going to take us another hour. But if you're welcome to read on this case. It's an interesting case. It's a 2020 case. But let's just get down to the ultimate issue. And here we have the same similar type of situation that we had in Hunt versus State. During appellant's cross-examination of the gardens officer, so this is again a police officer, defense counsel brought out that appellant's letter to police claimed he was innocent and was not a murderer. On redirect, the gardens officer testified that appellant told him in the interview that he had participated in the homicide as a lookout and had grabbed the victim's foot to throw him in the van. The following exchange then took place. Here we go. Here's the question. And defense counsel just asked you that isn't it true that the defendant in this case said, I'm not a murderer, correct? He said, yes. He asked you that? Yes, ma'am. Can you still be a principal to murder by what he did? Yes, ma'am. So this is exactly a conclusion. Can you still be a principal to murder by what he did? Aiding the other person in the murder, you are also considered a principal to murder. And he said, yes, ma'am. So here again, we have the police officer giving an opinion. And as you know, and again, it's an opinion about whether you are still a principal to the murder. And he said, yes. And this is exactly what the court held. The court held that, okay, first we talk about the objection, giving an opinion about his innocence or guilt. Here it was error to allow the guards officer to express the opinion that the defendant could still be a principal to murder by what he did. Not only did the officer apply a legal standard to a set of facts, which is the big no-no, but he also implicitly opined that appellant was guilty of murder under the principal theory. Okay, so under that theory, he was essentially saying that he was guilty. So that's, again, this was reversed because of that problem. So that's another case. And again, that case is, again, distinguishable because it's dealing with a police officer, and a police officer is just giving his opinion about whether the person is guilty or innocent. But what's, I think, even a little bit more interesting in this case is that when the judge made his finding in this case, the judge, with this specific issue, it was brought up, right? James Owens brought this specific issue up, that this was argued. If you're watching the trial, this was actually argued in the trial, that this expert is now giving an opinion about an ultimate issue. That's what James Owens argued. There was a response by the prosecution, and then the judge made a ruling. Now, the judge in his ruling cited a case. Okay, if there is a case that you should cite, if you're James Owens, and you want to argue that the judge made a mistake, you have to cite his case and show why your case is different than these other cases, or why your case was wrongfully decided, or distinguish or show how the judge made a mistake with that case, if that's what you want to argue. But the judge literally cited a case, and you don't find that case. You should say, if you're James Owens, you should say, Your Honor, in your brief, okay, forget about the argument. In your brief, you say the court cited this case for the basis which the ruling was, and this is the reasons why that was erroneous. But that wasn't done. It was like, come on, what case did the judge cite? I'll tell you, the judge cited a case called Dinkins versus State. So again, we're finding again, like, this is just, you got to do this. If you want to have any sort of chance, you've got to cite the case that the judge actually relied on and show why it's wrong, why the reliance on this case is wrong. But let's go through this case and see how it's very similar to what happened in Sarah Boone and why the judge felt that this case is on point. So here we go. In this direct criminal appeal, the defendant, Enoch Dinkins, seeks review of his conviction for sexual battery upon a mentally defective person and his sentence as a habitual felony offender. The defendant argues that the trial court erred in allowing the state psychologist to opine that the victim was not capable of appraising the nature of her conduct or of giving knowing, voluntary, and intelligent consent to intercourse. And that's going to be the very, very close to the ultimate issue. Essentially, it's the ultimate issue. And you have the psychologist giving an opinion that the victim was not capable of appraising the nature of her conduct. So here we go. The defendant also argues that Section 77.75.94 Florida statutes, habitual felony offender statutes, violates his right to trial by jury. We disagree and affirm. So first they talks about the admission of a psychologist's opinion as to whether the victim was mentally defective and capable of consent. So here's the statute. The statute provides that a person who commits sexual battery upon a person of 12 years of age or older, without that person's consent, commits a first-degree felony when the victim is mentally defective and the offender has reason to believe this or has actual knowledge of this fact. So it's without that person's consent and when the victim is mentally defective. So here we go. Florida statute provides that consent means intelligent, knowing, and voluntary consent and does not include coerced submission. Consent shall not be deemed or construed to mean the failure by the alleged victim to offer physical resistance to the offender. Florida statute provides that mentally defective means a mental disease or defect which renders a person temporarily or permanently incapable of appraising the nature of his or her conduct. So if you are able to prove that this girl was mentally defective, that means that the defendant is going to be guilty of this first-degree felony. So they cite some cases here, and eventually, in contrast, let me see where they come out with this. Okay. In contrast to the expert opinions discussed in these other two cases, in the instant case, the psychologist's opinions were not legal conclusions. The psychologist did not opine on the defendant's guilt or innocence. Rather, the psychologist opined only as to whether the victim was mentally defective and capable of consent to intercourse. Although the opinions did go to ultimate issues in the case, and this is where you can really kind of understand how to draw the lines here. It's a little bit nuanced here, and that's what's a little bit difficult. You got to think about this. But this is where we're going to really kind of get this understanding, which I believe I explained already, but I'm going to go through it one more time. Rather, the psychologist opined only as to whether the victim was mentally defective and capable of consent to intercourse. Although the opinions did go to ultimate issues in the case, because the Florida statute said, if the person is mentally defective, then that means that there was no consent, right? So by a psychologist saying the person is mentally defective, you're essentially saying that therefore that means that the defendant violated the statute, which is the question to the jury. So it's an ultimate issue. So here, this is what the court says. Although the opinions did go to ultimate issues in the case, Florida law expressly provides that an expert witness may render such opinion. Section 90.703 Florida statute provides that testimony in the form of an opinion or inference otherwise admissible is not objectionable because it includes an ultimate issue to be decided by the trier of fact. Thus, the jury had the power to accept or reject the opinions and was not bound by such. So, as we started off this whole discussion with this statute, which is extremely broad, that basically says, yes, testimony in the form of opinions, definitely expert testimony, would be admissible, even though it includes an ultimate issue. So even though the expert is going to give you an ultimate issue, giving an opinion about the ultimate issue of the fact, ultimate issue of that's in the province of the jury, still the broad statute says that would be allowed. So that's number one. Number two is what I think they're also trying to do, and I think it could have been done a little bit better in Dinkins versus State, is that, again, what the expert is testifying here is the what. What is this person's status? Is this person's status as a diagnosis mentally defective? And as a psychologist, you're able to give that diagnosis. So that's going to help the jury to determine whether this person is actually mentally defective. And then even though it will lead them to the ultimate issue of the case, but you're not just simply testifying that the person's guilty or innocent. You're giving a helpful diagnosis and explaining what this person is going through. And if that's what you can do, then you're helping the jury in being able to help diagnose what this person has. And then if that leads them down to, okay, well, that means that they're guilty, well, then okay. But again, I'm not just getting up on the stand and saying this person's guilty, this person's innocent. In the lawyer case, remember, there's not really anything helpful that the lawyer's doing. The lawyer's not saying anything what? They're not explaining anything. Everything was already laid out in front of them. The only question is, does that mean that they violated the policies or not? And that lawyer in that first case that we're talking about said, in my opinion, they didn't do anything wrong. But that's just your opinion to say whether they're guilty or innocent. You're not helping the jury at all. You're not aiding the jury to help them determine what happened. Remember, the jury is they're supposed to determine what the facts of this case are. So if you're able to help them in that determination, then as an expert, you can do that, even though that will then lead them to their verdict. So that's how I understand these cases. I think it could have been a little bit better done in Dinkins versus State. But again, it all comes down to, why would James Owens not cite this case? This is exactly the case that the judge cited. And if that's the case the judge cites, and you want the judge to revisit that, you should definitely do an analysis on that case and say, look, judge, in that case, that case is not the best written case, I think, from the case that we saw. And they're just going back to that original statute, which is very broad. And we saw some other cases that already cut away at that statute. So maybe Dinkins was not really applying the law appropriately. And that's maybe an argument that you could have made if you're James Owens, but you got to cite the case that the judge said he's relying on when he made that ruling in the trial. So that is going to be it for this argument, the fourth argument. Again, we're seeing that he's not going to get much with this argument either. And I think even at the appellate level, is not going to get much with this argument, because ultimately experts are given a lot of leeway about what they're allowed to testify about, what their opinions are. And as long as they're not saying guilty and innocent, a lot of times you're going to find that it's not going to be an abuse of discretion to allow them to testify in that. So again, this was the fourth argument that we went through. It was an interesting, some of those cases are interesting, and it's always interesting to see how jurisdictions deal with expert testimony when it comes to opinions about ultimate facts that the jury has to determine. So that's going to be it for now. Please, if you haven't done, please subscribe, like, and we will see you next time.